The People's Remedy and Restoration Act, the New Declaration of Independence, 2025, by Billy Powers, John Bloom, Tom Kibler, Matt Scarlatos, Tammy Reif, Rod Class Toll and Roll, TM, delegates. www.tollandroll.com. tollandroll2025@gmail.com. The People's Remedy and Restoration Act, the New Declaration of Independence, 2025. We, the people of these United States, in lawful assembly and in recognition of the petition of remonstrance, amicus brief and the affidavit of remedy has been formally delivered across 3 presidential administrations to the President, the Congress of these United States, the Supreme Court, the legislative bodies of each state, their respective governors, and to the legislative authorities of the District of Columbia, and over 600 state and federal offices, do hereby declare and affirm this act as the lawful instrument to restore constitutional governance and remedy systemic corruption. Since the founding of this nation, it has been the duty of the people to safeguard liberty, property, and family rights against tyranny and unlawful usurpation. Today, the sovereignty of the Republic is under direct threat from widespread fraud and systemic crimes perpetrated through counterfeit, forged, and perjured filings entered into our land and court records. These acts constitute treason and domestic terrorism under federal law and are further compounded by the unlawful use of digital platforms and software systems designed or operated without risk management or oversight, allowing corruption to flourish unchecked. Through this act, the people call upon their government to act decisively, to audit and recover all stolen property and records, to dismantle corrupted networks, and to ensure that such crimes can never again be hidden behind technology or private monopolies. This act is the lawful bridge between historic duty and modern enforcement, uniting the past, present, and future of our republic in a single demand for justice and restoration. Section 1. Short title. This act may be cited as the People's Remedy and Restoration Act. Section 2. Purpose. The purpose of this act is to restore constitutional governance, protect the sovereignty of these United States, and safeguard property, family rights, and retirement systems by addressing systemic fraud, treason, and domestic terrorism within the judicial system, land and court records, and the digital platforms and government agencies that manage and access these records. These platforms and agencies have been used to conceal fraudulent filings, counterfeit property records, falsified court judgments, and unlawful case entries, as well as to facilitate child and elder trafficking, unlawful property seizures, and estate exploitation under color of law. Whistleblowers have provided documented evidence that these systems operate without adequate risk management controls and often contain undisclosed backdoors and hidden financial pipelines, enabling private corporations and government entities to manipulate data and divert assets without public knowledge or lawful due process. Together, these systems and agencies form a nationwide network of organized fraud and trafficking, allowing the coordinated theft of homes, land, identities, deeds, children, elders, estates, and other assets of the people. This network constitutes not only organized crime, but also acts of domestic terrorism and treason, requiring immediate federal intervention and enforcement. This act establishes a national framework for lawful audit, recovery, and restitution, ensuring the return of stolen property and rights, the dismantling of corrupted systems, and the implementation of federally mandated constitutional safeguards to prevent future abuse. Section 3. Congressional Findings. 1. Counterfeit, forged, and perjured documents have been systematically entered into land record systems and court files, often through digital platforms such as ERDIS, SEQRE, Tyler Technologies, eFile, MERS, and others. 2. Whistleblowers have provided documented evidence that these systems are designed or operated without required risk management protocols and contain hidden backdoors that allow manipulation of records. 3. These crimes cross state lines and involve interstate commerce, triggering federal jurisdiction under Article 1, Section 8, the Supremacy Clause, and applicable federal statutes, including 18 U.S.C., paragraph 2331, and 18 U.S.C., paragraph 2381. 4. MERS has been shown through testimony and federal cases to lack oversight, proper audit trails, and has been used to conceal true ownership of property while enabling fraud at scale. 5. Neither state nor local agencies have implemented proper risk management controls as required by the Northwest Ordinance of 1787, resulting in unmonitored systemic fraud. Section 3A. Digital Systems Accountability and Transparency. A. Scope and Purpose. Congress recognizes that widespread systemic fraud has been enabled and concealed by a network of interconnected digital platforms spanning courts, land records, prisons, juvenile detention centers, welfare systems, healthcare systems, insurance agencies, banking institutions, law enforcement databases, and government agencies at the federal, state, and municipal levels. These agencies and private contractors often share access through direct integrations, vendor-managed portals, and administrative backdoors, allowing the manipulation of records and the transfer of sensitive data without judicial warrants or public oversight. The combined effect of this structure is a shadow network that has operated without proper constitutional oversight, risk management, or public accountability, resulting in the unlawful deprivation of rights and property on a national scale and undermining the sovereignty of these United States and the liberty of the people. This section establishes the framework for identifying, auditing, and dismantling unlawful data integrations and backdoor access points that have been used to traffic children and vulnerable adults, unlawfully seize property, conceal fraudulent filings, and manipulate financial and legal outcomes in violation of the Constitution and federal statutes. B. Covered systems and entities. The platforms and entities implicated include, but are not limited to, land and court record systems. 1. Electronic Recording Delivery Systems, ERDS, and SECURE, used for the electronic transfer and official recording of deeds, titles, liens, and other property records. 2. Tyler Technologies Odyssey and integrated land record platforms, including Eagle Recorder, form a unified ecosystem used by counties and municipalities across the nation. Odyssey is widely deployed for civil, family, probate, guardianship, and criminal courts, enabling digital case filings, judgments, and orders, while Eagle Recorder and related property recording platforms are used for deeds, mortgages, liens, foreclosures, tax sales, and transfers of title. These systems are interconnected, allowing a single vendor to control both the judicial process, through Odyssey, and the recording of property interests through Eagle Recorder. This integration has enabled the seamless concealment of fraudulent property transactions, counterfeit deeds, falsified judgments, and unlawful guardianship filings, bypassing constitutional safeguards and public transparency. E-file portals, operated by Tyler Technologies and other vendors, used to submit digital court filings, orders, and judgments without proper verification of authenticity, creating opportunities for forged or counterfeit documents to enter official court and land records. 1. Mortgage Electronic Registration Systems, MERS, is now owned and controlled by Intercontinental Exchange, IC, the parent company of the New York Stock Exchange, NYSE, and other global financial markets. MERS has been shown through sworn testimony, federal investigations, and court cases to lack oversight, independent audit trails, and lawful transparency, and has been repeatedly used to conceal the true ownership of property interests, bypass constitutional recording requirements, and enable fraud on a national and international scale. Through its integration with securitization markets and derivative instruments, MERS serves as a private, unregulated shadow registry, allowing bundled mortgage assets to be traded in global financial markets without disclosure to property owners or public recording offices. This has enabled the laundering of fraudulent property transfers, the concealment of counterfeit mortgage assignments, and the manipulation of property titles to generate profit in secondary and tertiary markets. By placing control of this registry under a private corporation that also operates global stock exchanges, a direct conflict of interest exists that threatens the sovereignty of these United States and undermines the constitutional right of the people to secure property under lawful, transparent systems. Protective Services and Guardianship Systems. 1. NAPIS, National Adult Protective Services Information System, and LEAPS, Legal and Adult Protective Services, which manage APS investigations and guardianship matters. 2. SAC-NWIS, our CCWIS systems, which manage CPS cases and, in some states, overlap with APS and guardianship functions. 3. These systems have been tied to child and elder trafficking, fraudulent guardianships, and unlawful seizures of estates and assets. Law enforcement and criminal databases. 1. LEADS, Law Enforcement Agency's data system, and NCIC, National Crime Information Center, which track warrants, arrests, and criminal histories. 2. These systems sometimes directly interface with courts and welfare agencies, allowing unlawful interventions and removals based on fabricated or altered records, prisons, juvenile detention, and monitoring systems. The following private entities and their platforms are identified as examples of the interconnected systems contributing to systemic fraud and abuse. This list is illustrative and not exclusive, as other contractors and programs may also fall under the scope of this act. 1. The GEO Group, Inc., a major private corrections corporation operating prisons and detention centers nationwide under federal, state, and local contracts. 1. Abraxas Youth and Family Services, a GEO subsidiary, manages juvenile detention and treatment facilities, including but not limited to the Abraxas Academy in Morgantown, Pennsylvania, and Abraxas Youth Center in South Mountain, Pennsylvania. 3. BI Incorporated, also owned by GEO, operates the Intensive Supervision Appearance Program, ISAP, under contracts with the Department of Homeland Security, DHS, and Immigration and Customs Enforcement, ICE, using GPS ankle monitors, digital check-in tools, and case management platforms to track and supervise individuals under government oversight. These integrated systems directly connect court orders, prison populations, juvenile placements, and digital monitoring programs, creating an ecosystem that is highly vulnerable to abuse, fraud, and manipulation. Insurance, healthcare, and welfare systems. 1. Medicaid Management Information Systems, MMIS, Medicare databases, and state welfare portals. 2. State departments of insurance and private insurers connected to these systems for claims processing. 3. These integrations have been exploited for fraudulent billing, unauthorized guardianships, and the diversion of benefits and estates, financial institutions, and banking networks. 1. Systems such as ACAPS, Automated Claims Access Processing Systems that allow direct, real-time communication between courts, banks, and title systems. 2. These connections enable unlawful freezes, seizures, or transfers of funds and property based on fraudulent or counterfeit digital filings in violation of 12 U.S.C. Paragraph 3401 et CQ, Right to Financial Privacy Act. C. Backdoor access and data sharing. 1. Many of these platforms are linked through undisclosed vendor interfaces, administrative backdoor accounts, and interagency agreements. 2. This structure enables private corporations, banks, and government agencies to share data without judicial warrants or individualized due process. 3. Such practices violate the Fourth Amendment, which protects against unlawful search and seizure of private data, the Fifth and 14th Amendments, which guarantee due process and equal protection of law. Article 1, Section 8, which limits the regulation of commerce and public records to Congress. Article 4, Section 4, which guarantees a republican form of government. And Article 6, the Supremacy Clause, which establishes that federal constitutional protections override conflicting private or state systems. D. Statutory violations. The operation and concealment of these systems constitute violations of multiple federal statutes, including 1. 18 U.S.C. Paragraph 1030, Computer Fraud and Abuse Act, prohibits unauthorized access or use of computer systems. 2. 18 U.S.C. Paragraph 1341-1343, mail and wire fraud, applies to fraudulent schemes conducted electronically or via mail. 3. 18 U.S.C. Paragraph 1962, RICO, prohibits racketeering through enterprises involving ongoing systemic fraud. 4. 18 U.S.C. Paragraph 2331, defines and criminalizes domestic terrorism. 5. 18 U.S.C. Paragraph 2381 defines and criminalizes treason. E. Congressional action required. Congress hereby declares that 1. These interconnected digital systems constitute a national security threat. 2. They shall be audited in full and, upon discovery of unlawful backdoors, counterfeit filings, or fraudulent integrations, shall be immediately dismantled and federally seized to protect the people, the Constitution, and the sovereignty of these United States. The owners, operators, and controlling parties of these systems shall be held personally and criminally liable for their role in the creation, concealment, or operation of unlawful backdoors, counterfeit filings, or fraudulent integrations, with no immunity or protection from prosecution under this Act. 3. Private corporations and government officials found complicit shall be subject to prosecution for treason, domestic terrorism, wire fraud, RICO violations, and USC. Paragraph 241-242. 4. Federal oversight shall be established to ensure transparent, constitutional, and tamper-proof record systems going forward. F. Purpose of this section. This section forms the bridge between congressional findings and the declaration of national emergency, providing the factual and legal basis for federal seizure, audits, and enforcement actions mandated under this Act. Section 4. Declaration of National Emergency. The fraudulent manipulation of land and court record systems constitutes a national emergency under 50 U.S.C. Paragraph 1601 et seq. Such actions are declared as domestic terrorism under 18 U.S.C. Paragraph 2331 and treason under 18 U.S.C. Paragraph 2381. They also constitute deprivation of rights under color of law under 18 U.S.C. Paragraph 241-242 and obstruction of justice under 18 U.S.C. Paragraph 1503. Section 5. DOG Audit and Recovery Authority. DOG shall act as the federal executor of this Act, with exclusive authority to audit and recover assets, records, and systems compromised by fraud. Audit scope. All physical land and court records shall be subject to audit, including every digital system used for record management such as ERDS, SEQRE, Tyler Technologies, eFile, MERS, and equivalent platforms. The audit shall also encompass all databases connected to public records, including, but not limited to, Child Protective Services, CPS, Adult Protective Services, APS, guardianship, probate, municipal, state, and private systems that directly or indirectly interface with land and court records. Recovery powers. The federal government is authorized to immediately seize corrupted systems and fraudulent records, including all related digital evidence such as source code, logs, and access credentials. A national registry of fraudulent instruments shall be established to track counterfeit filings and prevent concealment. In addition, a secure hotline shall be established, accessible via telephone and the internet, to allow victims and informed individuals to report evidence of fraud or criminal activity for investigation and enforcement. Accountability for fraudulent filings and recordings. Congress finds that current statutes fail to adequately punish the creation, filing, and recording of fraudulent property documents, even when such documents are later used to commit wire fraud or other crimes. Whistleblowers have provided evidence of systemic nationwide schemes involving thousands of victims in which fraudulent business entities, shell corporations, and fabricated LLCs are created and falsely presented as legitimate financial institutions, including under the name Bank of New York Mellon as trustee. These entities conceal the true party and interest, creating the false perception of lawful authority to foreclose, seize, or transfer property and assets, while shielding the actual perpetrators. Congress finds that the federal prosecution of Patrick Joseph Soria, e.g., U.S. v. Patrick Joseph Soria, case number 2-101-CR0049 JFW, C.D. Kaldauer, and related actions in California and Montana. The case of Patrick Joseph Soria, convicted in 2021 for conspiracy to commit wire fraud and contempt of court after defrauding over 2,000 homeowners and lenders, demonstrates this systemic failure. His scheme relied on the recording of counterfeit deeds and falsified title documents across multiple states, causing over $7.6 million in verified losses. However, no penalties were imposed for the act of recording these fraudulent documents, leaving the core crime unpunished and hundreds of trillions of dollars in cumulative damages unaddressed, harming both victims and the national economy. This act closes that loophole by establishing that any person, entity, or agent who knowingly prepares, files, records, or causes to be filed or recorded any false, counterfeit, forged, or perjured document affecting land, court records, or dockets shall be guilty of a distinct and separate offense in addition to charges for subsequent fraud. Such conduct shall be prosecuted under 18 U.S.C. paragraph 2381, treason, 18 U.S.C. paragraph 2331, domestic terrorism, 18 U.S.C. paragraph 1341, 1343, mail and wire fraud, and related federal statutes. Civil remedies shall include restitution to victims, treble damages under 18 U.S.C. paragraph 1964 and 42 U.S.C. paragraph 1983, and the seizure of all profits, property, and assets obtained through fraudulent filings. Penalties shall also include permanent disqualification from holding any fiduciary, recording, judicial, or administrative role related to public records, mandatory restitution to restore the property and rights of victims, and federal prosecution as acts of treason and domestic terrorism where systemic fraud has been proven. Fraudulent transfers, tax evasion, and judicial complicity. Congress finds that fraudulent property transfers, including the use of straw buyers, shell corporations, credit bid manipulations, and secret agreements, have been systematically employed to evade taxation, conceal beneficial ownership, and unlawfully seize property without proper public oversight. Through these schemes, fraudulent documents are recorded through private systems such as MERS, e-file portals, and proprietary county recording platforms. These transactions appear legitimate while masking taxable events and shielding illicit gains, depriving federal, state, and local governments of hundreds of billions annually in property, transfer, income, and capital gains taxes. This conduct contributes directly to the U.S. tax gap, which the IRS estimates at over $600 billion each year, representing a catastrophic loss of public revenue and undermining the economic security of these United States. Illustrative cases and patterns of abuse. Straw buyer fraud. In San Diego, Timothy E. Shanahan pled guilty in a $5 million mortgage fraud conspiracy, using falsified identities and fabricated documents to obtain property loans. These transactions were funneled through official recording systems, concealing taxable income and creating counterfeit ownership records that appeared lawful while perpetuating systemic fraud. Judicial corruption. In Michigan, Supreme Court Justice Diane M. Hathaway manipulated property transfers among family members and shell entities to engineer a fraudulent short sale on a $1.5 million home while retaining a debt-free Florida property. Despite a felony conviction for bank fraud, the underlying fraudulent recordings were never seized or reversed, leaving public records corrupted and tax liabilities uncollected. Federal concealment via FHFA. Evidence contained in the binders delivered to DOJ and congressional committees demonstrates that the Federal Housing Finance Agency, FHFA, contracts with law firms and third-party servicing entities to conceal its role as the true beneficial party of interest in property and mortgage transactions. These secret agreements are structured to bypass proper public recording and obscure federal involvement from victims, and at times from judges themselves. When victims present evidence of counterfeit or perjured filings, courts that ignore these claims become accessories by willful blindness, further eroding trust in the judiciary and the rule of law. These examples reflect a national pattern of systemic fraud, in which fraudulent documents are created, filed, and recorded to facilitate tax evasion and concealment of true ownership. Public records are corrupted at the source through MERS and private recording networks, and government agencies, including FHFA, knowingly participate through secret agreements that disguise their interests and obstruct transparency. This conduct has left billions in fraudulent gains hidden, with cumulative losses to the people and treasury measured in hundreds of trillions of dollars over decades. The civil and criminal penalties for these acts are established elsewhere in this act. This section affirms that tax evasion, judicial self-dealing, and concealed federal agreements are inseparable from the larger counterfeit and forged document crisis, and that they pose a direct threat to constitutional governance and the sovereignty of these United States. End perpetual property tax. Perpetual property taxation is prohibited. Property taxes shall be limited to lawful, finite assessments necessary for the administration of essential local government services, and shall not create a permanent lien, encumbrance, or forfeiture condition against private property. Title to private property shall be considered absolute upon lawful purchase and recording, free from any recurring tax obligation that would extinguish or diminish ownership rights. No property may be seized, sold, or transferred solely for non-payment of property taxes unless and until a final judicial determination has been made in open court, with full due process protections under the 5th and 14th Amendments. Any tax foreclosure or property seizure conducted without such judicial determination shall be deemed void ab initio, fraudulent under this Act, and subject to federal seizure and prosecution under 18 U.S.C. Paragraph 241-242 and related statutes. Section 6. Required Risk Management Systems. All record systems, whether physical or digital, must meet federally mandated risk management standards, including tamper-proof audit logs, encryption, verified identity access controls, independent third-party inspections, and continuous monitoring. Governors shall certify compliance annually for state-level systems, and state judicial branches shall provide full access and cooperation to federal oversight authorities. Failure to comply shall result in immediate federal receivership and DOJ takeover of the affected systems. Any undisclosed backdoors found in ERDS-type systems shall be permanently removed under federal supervision and prosecuted as national security offenses. Mandatory wet ink signature requirement. All core legal instruments, paperwork, or documents, including but not limited to those affecting property, family rights, guardianship, probate, child or elder cases, and court judgments, shall be executed with original wet ink signatures by the responsible parties and officials. No legal instrument shall be recorded or caused to be recorded into any land record, court record, or docket without such original wet ink signatures. These original documents shall be preserved in secure physical archives and maintained in a manner that guarantees their integrity, while ensuring accessibility for public oversight and independent audit. Digital copies may be used for convenience and public access, but they shall not replace or supersede the requirement for physical originals. Any attempt to record, submit, or enforce a digital-only instrument in place of a wet ink original shall be deemed void and fraudulent under this Act and subject to federal seizure and prosecution. No judge or court officer may accept, rely upon, or act upon any document that is a copy rather than the genuine original wet ink instrument required herein, except by the explicit written agreement of all parties to the case. In any proceeding where a party asserts that a document is fraudulent or challenges its authenticity, the judge shall be legally and lawfully required to demand production of the original wet ink instrument. Any failure by a judge to require and verify the original shall constitute willful misconduct, a violation. Any judge, court officer, government official, or private actor who knowingly accepts, relies upon, or enforces a counterfeit, forged, or perjured document in place of a genuine original wet ink instrument shall be guilty of willful misconduct and a violation of constitutional due process. Such acts, when part of a systemic scheme to seize property, remove children or vulnerable adults, or obstruct the lawful functioning of government, shall constitute domestic terrorism under 18 U.S.C. Paragraph 2331 and treason under 18 U.S.C. Paragraph 2381, and shall be prosecuted accordingly under this Act. Any case, proceeding, judgment, or action found to rely upon counterfeit, forged, perjured, or digital-only documents in violation of this Act shall be deemed void ab initio and of no legal effect. In such instances, immediate judgment shall be entered in favor of the victim and damaged party, including the return of all property, rights, and assets wrongfully taken. All damages, including but not limited to economic, property, personal, and consequential harm, shall be trebled and awarded as mandatory restitution to the victim or damaged party, and the matter shall be mandatorily referred for federal prosecution and the imposition of all applicable civil penalties and sanctions as required by law. Section 7. Office of PROTECT. The Office of PROTECT, Preservation Republic Oversight Task Force through Executive and Constitutional Trust, is hereby established as an independent constitutional body of, by, and for the people of these United States. It shall exist to ensure that the people have a direct and accessible forum to bring their cases, grievances, and demands for redress, free from obstruction or corruption by private entities, courts, or monopolistic organizations. While fully independent, PROTECT shall coordinate and cooperate with the lawful functions of the United States government, including its executive agencies, Congress, and law enforcement bodies, for the purpose of securing justice, protecting victims, and enforcing the provisions of this act. Such coordination shall not create subordination, merger, or dependency, and PROTECT shall retain sole constitutional authority to act on behalf of the people, free from external control or political interference. PROTECT shall have express authority to investigate, audit, and hold accountable members of the judicial branch, including judges, clerks, officers of the court, and associated entities, for systemic fraud, deprivation of rights under color of law, or violations of constitutional duties. This authority shall extend to state and federal courts where evidence demonstrates that judicial officers have acted outside the lawful scope of their Article III or state judicial authority. In exercising this power, PROTECT may initiate independent investigations, compel the production of records, and certify findings of fraud or constitutional violations to Congress, the Department of Government Efficiency, DOG, and appropriate federal enforcement agencies. PROTECT may also issue recommendations for impeachment, removal, or criminal prosecution of judicial officers engaged in treason, domestic terrorism, systemic fraud, or organized deprivation of rights. The judicial branch shall not interfere with, limit, or obstruct the actions of PROTECT in performing its oversight functions under this Act. Such oversight shall be considered a constitutional check and balance, and shall not be deemed a violation of judicial independence, as no branch of government may operate above the Constitution or outside the rule of law. In fulfilling this mandate, PROTECT shall serve as both an oversight authority and a constitutional trust, empowered to act as the lawful protector, advocate, and enforcement arm for the people. This includes representing victims, initiating bounty enforcement actions, and exercising independent investigative and policing powers to address systemic fraud, trafficking, unlawful takings, and deprivation of rights under color of law. PROTECT shall ensure that all remedies, audits, and recoveries under this Act are carried out faithfully, transparently, and in strict adherence to the Constitution, thereby safeguarding the Republic and restoring lawful governance. A. Governance. The initial governing body of PROTECT shall consist of the framers of this Act, who shall serve as the founding board of directors. This board shall establish bylaws and procedures for PROTECT's operation, maintain strict independence from government agencies and private membership organizations such as the American Bar Association, ABA, and ensure that all leadership transitions are conducted transparently and with proper public notice. Membership integrity is mandatory. No member of PROTECT may hold office in or have financial ties to any entity implicated in fraud or trafficking addressed by this Act. Any conflict of interest shall result in immediate removal and permanent disqualification from service. B. Constitutional authority. PROTECT shall operate under the authority of Section 4 of the 14th Amendment, which authorizes enforcement actions by the people to remedy systemic violations of rights. It shall also rely upon federal whistleblower and qui tam statutes as codified in 31 U.S.C. § 3729, 3733, civil rights enforcement laws as codified in 42 U.S.C. for 1983 and 1988. An oversight authority derived from the Northwest Ordinance of 1787 and the original constitutional framework of the Republic. Section 13. Incorporation of foundational documents. By reference, geste. Purpose and authority. The documents listed below are hereby incorporated by reference into this Act as integral and binding components of its purpose, implementation, and interpretation. These materials provide the historical foundation for this Act, the lawful demand and remedy process initiated by the people, and the constitutional and statutory framework necessary to enforce compliance at both the state and federal levels. B. Incorporated documents. The following documents are hereby incorporated by reference and shall be physically attached to this Act, recognized as integral, binding components of its purpose and enforcement, and afforded full statutory authority. These documents serve as official guidance to ensure lawful implementation, interpretation, and remedy under this Act. Appendix A shall contain the original petition of remonstrance submitted by the people to the President, Congress, the Supreme Court, and all relevant federal and state offices, constituting the lawful demand for remedy and the restoration of constitutional governance and Republican government in accordance with Article 4, Section 4 of the United States Constitution. Appendix B shall include the amicus brief, presenting supporting legal arguments, case law, and constitutional interpretation that reinforce federal jurisdiction and lawful remedy. Appendix C shall contain the sworn final affidavit of remedy, establishing crimes, harms, and required remedies. This appendix provides the framework for victim restitution and the return of property through the People's Remedy and Restoration National Recovery Fund. Appendix D shall contain the evidentiary record and supporting documentation presented to the Department of Government Efficiency, DOGE, by the framers and whistleblowers, hereinafter referred to as the Whistleblower Evidence Binder. This binder, known as Binder 2, includes examples of counterfeit, forged, and perjured documents, records of systemic fraud and trafficking, and whistleblower statements that demonstrate the unlawful acts and criminal networks addressed by this Act. The materials contained in Appendix G shall serve as evidentiary guidance for enforcement, audit, and prosecution under this Act. These documents are to be held under seal, with identifying information and victim data protected in accordance with federal privacy laws and accessible only to authorized federal agencies, DOGE, and the Office of PROTSCT, for lawful oversight and verification purposes. Appendix E shall include the full text of the Northwest Ordinance of 1787, reaffirmed as foundational law governing state obligations for land management, court integrity, and maintenance of a Republican form of government. Appendix F shall contain the white paper on Northwest Ordinance compliance, which provides modern guidance and standards for governors and state commissions to ensure compliance with Sections 8 and 9 of this Act. Appendix G shall contain the Declaration of Framers and the formal documentation for the formation of the Office of PROTECT by C. Legal effect. These appendices shall carry the same force and effect as the statutory language of this Act. In the event of ambiguity or dispute regarding implementation or interpretation, these documents shall control as guiding authority, ensuring that the intent of the people and the framers of this Act is fully preserved. All federal and state officials are required to review and adhere to these materials in carrying out their duties under this Act. D. Public access. All appendices shall be published in full with every copy of this Act, made permanently available on official federal and state websites, and distributed to all state legislatures, governors, and state commissions. Section 14. Effective date. This Act shall take effect immediately upon enactment.